Now we're in a world where, as often happens, the market has shifted in terms of what's commercially reasonable. And I would say this about any transaction of any kind. Your key objective is to get a commercially reasonable deal. You've got to get creative and then keep the option open of a hard no.
All right, we're here today with Emons Holmquist, Seattle real estate attorney, and we're going to dive in on what I called Ask Your Attorney. So questions I get most often from apartment owners, managers, and the like. So Emons, thanks for coming today. We've interacted on some transactions and some questions about leasing and landlord-tenant laws, but tell us a little bit about your firm, your background, and then we'll dive in.
Absolutely, and thanks for having me. We are a 9-attorney firm at Holmquist & Gardner. Founded in 2008, celebrating our 15th anniversary. Happy to serve clients in the real estate and business arenas and also estate planning. And we're set up to be full service for real estate owners, developers, managers. And it's obviously been great over the years working with you. It's a select group of brokers that we really rely on, and you and your team have been one of them. So really happy to be here and address any questions you have.
Great. Let's kick it off. I was going to wait till later to break the ice, but it is the number one most talked about and questions I get from owners. They call it eviction. You call it unlawful detainer.
Yep.
What are we talking about?
There it is. Yeah. Well, unlawful detainer, eviction isn't really a legal term.
Okay.
It just refers to the general process of sort of getting somebody out of the property.
Okay.
Unlawful detainer is one of the two causes of action, unlawful detainer and ejection.
Okay.
And it's essentially who has a right to possession. Unlawful detainer is a process that was set up to expedite a evaluation of who is entitled to possession in King County.
Okay. And
ejectment is based on who has superior title. So those are sort of the two ways that we move people out of the property on a legal basis. Before all this, they had self-help. Self-help is something that people recall maybe from like the 70s or I don't know when, but hey, I don't like the fact that you're not paying the rent, so I'm just going to go ahead and turn off the water or the heat.
And this was legal?
Well, I wouldn't. At that point, they didn't have the Washington Residential Landlord-Tenant Act.
Okay.
So these protections didn't exist. Okay. So regardless of anything I or any attorney says about this or how much we're concerned about what this generally means as a tax on our real estate or an infringement on our constitutional right to own property and do what we want with it, the whole pretense here is that if we didn't have this law, then bad actors would take every opportunity to be bad actors. So,
okay. Speaking of bad actors, what happened with the pandemic? And I'll take a step back. We analyze building values, right, based on income and expense. Pre-pandemic, I never underwrote this delinquency line item. It just wasn't a thing, right? We had vacancy and concessions maybe, and that was like it from a leasing perspective. And now we have this bad debt or delinquency. So it feels new. It's not new. What changed in the pandemic that made that just skyrocket?
Yeah, and I think you're correct to isolate that as a dividing line as the pandemic.
Yep.
I know for the first decade of my practice, if people had evictions work, it was typically send a notice and then maybe serve a summons and complaint, get a show cause hearing on the board, and then the tenant would either move out or pay the rent. Okay. We in the case of COVID, we decided, our local governments decided that we needed to have a moratorium on evictions, and as that came into place, for whatever good was intended, the unintended consequence was we just had a slew of tenant protections that went very broad and ended up as one factor. The court system itself as another factor sort of got backlogged as we tried to process all of these. And the timing was all off. Now, instead of just like a few evictions now and again, it was like, okay, well, there haven't been any for this period of months or time, and now they're all going to be processed through. And as tenants realized that they didn't have to pay or that there were all these rights, having nothing to do with the aforementioned, protection against the water being turned off and all that, advantage was taken. And I'm sure you've heard about this.
Oh, yeah. I've witnessed it.
And look, there was a concern during COVID that I don't want to overlook, that homelessness might increase the spread of COVID and all that. I'm not a scientist. I'm not in the middle of it. I certainly didn't have anything to do with the policy making or legal decisions. But the folks in charge put that in place, and then we got everything that we're dealing with now.
Okay, makes sense. So fast forward to today, pandemic for the most part is behind us. People still talk about it. We've got like the 13th booster or something of that nature. I own an apartment building. Someone stopped paying 2 months ago. I went to them and said, hey, rent's due on this date. There's a late fee that I'm assessing here. And they're just like, hey, I'm never going to pay you again. Like, it's very clear you've got someone is it unlawfully detaining your property?
Yeah, well, at that point, they haven't paid pursuant to the lease.
Yep.
So their right of possession has been extinguished, at least contractually. Now we have to get a judicial ruling that, in fact, they're no longer entitled to possession.
So ring, Emons, this is the issue. What happens next? And can I have this person removed from my property based on the contract that we have in place as a property owner and a property resident?
Well, the short answer is yes.
Okay. And what's that?
The much longer answer is, how long is it going to take you?
Okay.
What are the attorney's fees going to be?
Yep.
What defenses might they raise
Yep.
that have nothing to do with payment of the rent, as you might imagine?
Yeah.
And what protections have been placed, statutorily for them?
Yeah.
And what timelines are the courts going to be able to help us out with?
Those are the next 5 questions. I'm just going to sit back now. Hit them in that order.
Well, and
awesome.
I'll preface everything I'm saying that,
Yeah.
Look, I run our transactions team,
Yeah.
and as a part of that, we have many multifamily owners and management companies.
Yep.
And the evictions team is typically more in our litigation department, but I unfortunately have to be on these calls. So I know enough to give some pretty good explanations, but every one of these is super nuanced.
Yeah, for sure.
And fortunately, at Holmquist and Gardner, we have a team that can get in the weeds.
Yep.
The problem is every single one now needs this kind of attention.
Totally.
And in the past, the folks that did unlawful detainers primarily in the city were set up to, fire off a notice, do this. It's sort of a mill-like setting.
Yep.
And we're kind of no longer in that world.
Okay.
If you want to have a successful eviction, unfortunately, you need to have a hands-on approach looking at all of the details for each one, and then trying to figure out what to do when it turns out the facts are bad. Bad facts include situations where there are totally different circumstances that you had no idea were the case outside of the rent. The other factor that we have is that in the past, it might be that a tenant would say, look, I know that even if I get legal help, meaning the Housing Justice Project or otherwise, the end result will be I'm probably going to be out in a month or so because the process is going to actually function. At present, they know that if I do all these things, it's actually going to be 2 to 3 months or longer. And so that's why you're getting this, no, I'm not paying the rent, and now, I don't want to get too far into what the policy should be or how it should change. These are just the realities that we're seeing.
Okay. So speaking of, let's talk approximate or rough timeline and cost. Say this situation I just described of this person hasn't paid for a few months is real, and I call your firm. What am I looking at from amount of time? And we know it doesn't go perfectly well, and then what it'll probably cost.
Yeah. So patience is a virtue here.
Yeah.
Ultimately, it varies greatly depending on the facts and circumstances of the matter. But we do know that, and also what county you're in. So the jurisdiction is going to matter. Now, King County's got its own court system, Pierce County, et cetera.
Most of what we do is in King, so I'd say that's a good starting point.
So a contested non-payment of rent eviction in King County right now can take up to a year.
Okay.
And contested means they come with some other defense as to why they should be entitled to possession.
And can that be anything, like with no basis? Just like, hey, I don't feel like paying.
Well, I don't think they're going to survive too long with just I don't feel like paying.
I lost my job or XYZ happened.
Basically,
like
some kind of school with the kids. There's anything you can imagine can be put forth. But a lot of it has nothing to do with their actual arguments. It's just the fact that the court system is a little bit backed up, and actually getting that hearing on the books is one thing. Once you do get a hearing and some evidence is presented, you're kicked into a trial, which is obviously expedited. It's not like a normal trial, but you're in a world where that all takes time to sit out, to be waiting all the statutory notice periods before you even get to that stage. So you got a few months. And then now you're waiting for court hearing dates, and then if they have some filings, now you're given time to respond. And this gets to how much will this cost?
So I guess zooming in a little bit, in this year process, you said it takes a few months even just to get to that court hearing.
Yeah.
What are the notices? Like, what's the back and forth that's typical in that scenario?
Yeah, so very broadly, and obviously if anyone's listening to this, don't rely on this as legal advice, but you're going to definitely get out a notice to pay or vacate.
Okay.
Typically that's a 30-day notice. It's got to be served properly.
Okay.
And that's where we lose a lot of people right away is the client comes in and they've served a notice, but it's either not for the duration required or the content of the notice isn't properly drafted, or you're in a world where service, meaning how it's delivered, wasn't proper.
Okay.
Assuming you get through that and that's all done and there's no payment at that point, now you're looking at serving a summons and complaint and a notice of a show cause hearing.
Okay.
And you've got a minimum of another 20 days to respond to that, depending on when that show cause hearing is.
Okay.
And so you're looking at, and then the show cause hearing, they'll give you a date for that, which may be 30, 60, or 90 days out, depending on the court's availability.
Gotcha. So,
And all this is subject to change. So anything I'm saying is like, wow.
So a month on the first notice, about a month on the second, and then anywhere from 1 to 3 months, to get to there's a court hearing. So now we're 5 months into this, and you say everything goes about how it should. You got another 6 or 7 to go. What am I in all in and cost just in attorney's fees? Forget what is not being paid.
Right. So assuming nobody has any issues and there's no arguments whatsoever, it could range from $4,000 or $5,000 all the way to like $8,000 all the way through.
Okay.
And those are definitely approximations,
Yep.
but yeah, it could easily get to about $8,000.
Okay.
And then it goes up from there based on how much it's contested, what issues are raised and defenses
And if
raised.
this person hasn't paid me rent in a year plus, I'm guessing the court's not going to enforce them covering my attorney's fees. I'm just happy to get the unit back.
So you're right on that you're happy to get the unit back. That is the priority.
Yeah.
The issue isn't so much that the court won't enforce it, it's that it's likely the tenant doesn't have it to pay.
They don't have it to pay.
So now we're talking about what is our time worth in pursuing that and whether to incur attorney's fees.
Yep.
Sometimes there's a reason to do it. You can collect.
Yep.
It's unusual, to be honest.
Okay.
And particularly with the tenants that have elected not to pay,
Okay.
you got to imagine they're in a situation where they're not fearful of whatever their record is as a tenant. They're not looking for a nice letter of recommendation or a friendly phone call.
Yep. Okay. So that's the traditional system. It's flawed in all the ways that we've discussed. What are some other ideas that you've either utilized or could recommend that maybe divert from the traditional notice and eviction process?
So typically,
like solutions, I guess, that aren't.
Well, you're maybe getting at sort of a cash for keys scenario
like that,
where we're talking to the tenant about creative resolution of the matter, which can arise even once you start the process.
Yeah.
And I think that's sort of key to the whole thing is, as you've already experienced, trying to do this stuff without maybe the firm hand of the law behind you. I think it's whatever I would say is a proactive solution starts and ends with having legal counsel, getting the appropriate notices out that you know are correct, having a lease that's compliant right off the bat.
Okay.
We definitely recommend the RAWA lease form, and that's a great organization. If anybody's,
for sure.
not signed up for that and you own multiple properties, like you should be doing that.
Yep.
And once you've then got the legal process going, then typically if there's counsel on the other side, you're able to sort of talk about solutions.
Okay.
And that's like the number one alternative to going all the way.
Yep.
And that usually can be, a little painful because you're talking about, well, maybe we need to give a little bit of money away here, or maybe we need to talk about some term beyond which things are going to happen.
Yep.
And here again, we're in this world where, unlike in the past, where we just had notices and things happened or didn't happen, we're in a new world.
Yep.
And these things are evolving literally month to month.
Yep.
What works, what doesn't, and what's allowed and what's not.
Okay. Last question on eviction, unlawful detainer. Let's say I'm cowboying, there is no attorney, and I'm literally cash for keys. I have the cash in my hand, they have the keys in theirs, and we exchange them. Are we done? Like, have they given or forfeited their unit back to me, or should I have them sign something, or what am I looking at?
Yeah, most attorneys in the room are going to have you sign something that just says, hey, the lease is terminated and we vacate it. We agree that there's no right to possession. The difficulty comes with security deposit issues and whether you've reviewed the unit or all the costs surrounding are generated from the property to make sure that you're not owed anything else.
Yeah.
So there's all these like practice tips for management that are less legal, more practical.
Yeah.
But yeah, we would typically want something executed that says, I'm out and I agree that that's what this is, to avoid being in court and explaining that, no, we made a deal orally.
Yeah.
See, he gave me the keys. I gave them this pile of cash.
Yeah.
I would try to document that payment, as you might imagine, and leave yourself in a world where there's a couple of different ways to demonstrate evidence of what happened. Photographs, a document, documented payment, that payment being cashed, all those things.
Makes sense. That leads me to like one more nuanced one, all your opinion. Is this generally something that you could have prevented or your manager could have prevented this non-payment tenant, or is it just really hard to know?
Wow, you're hitting that's a great question because along with our real property owners, we represent a lot of management companies. And, proud to be a resource for them. But we hear it from both sides of the table in terms of who's frustrated with who. And it is absolutely the case that there is not much the well-provisioned and prepared property manager can do to avoid, having that tenant who figures out the system and games the system. And the worst situation is where both sides are pretty proactive and sophisticated, both the property owner and the property manager. And you're using the right forms and you're doing all the right things. And there's this wily tenant. And now we're at $10,000 in legal fees. And now we're at 20 because we're redoing a hearing that happened. And it escalates. And there's really nothing anybody can do. Even the attorneys, unfortunately, because the facts are being raised on the spot. And this is back to what I was saying earlier about control and understanding what we can control and what we can't. So the best way to be right now is just prepared and patient. And if you have some patience, then you're going to, the expectation at the end of the day is that, hey, we may or may not prevail and as timely as I would like, but we're doing everything right towards that and taking all the steps necessary.
So new topic. I think in March of 2022, we were structuring a ton of purchase and sales. Interest rates were still about 3%. And then boom, they didn't go up a point, half a point. They doubled over the next 3 to 6 months. So it's impacted property values substantially and largely driven by high interest rates, making it very difficult to cash flow, especially in those early years if you're going to buy and reposition a property. So new topic for us, seller financing came to be. And I'd say we went from 0 seller finance deals over the course of about 250 sales now to about 1 or 2 out of every 10. So brand new to us and our clients, but seller financings come into play, usually because the owner wants to boost the value by offering a lower interest rate than the buyer could achieve. So I know you're very involved in this and purchase and sale agreements. What is common consideration for seller financing? Like what's like kind of right out the gate when a client calls you and said, I'm thinking of doing this. What do you advise?
Sure, and I would just note that we're on the same page with the trend there. We went a lot of years where this just wasn't a thing. Maybe a few family deals, like interfamily you might see or inter-office, like, okay, there was some sort of a favor we're going to do. But my first reaction is always just to sort of talk to the client about what it means to be a lender. Most folks kind of go, I want to do seller financing, and for better or worse, the brokers bring it up as a concept, and say, we can do it. It's no big deal. And it's one of those things where I'm like, wow. And I started doing an eye roll because so it's no big deal to be a bank. First and foremost, I mean, the actual legal documentation can be pretty simple. It's not, but the bigger considerations are that now you are going from a property transaction where you're just buying and selling and we're going to be done for the most part, to a longer term relationship with that person or entity on the other side. And so the first consideration is like, hey, how long are you prepared to sort of be in this deal? Because if it doesn't get fully paid, you may wind up with the property again. And you want to make sure that you're prepared for all the risks associated with lending and perhaps owning the property again and being a bank. Now, you're not a bank. If it's a family that's owned the property forever, I mean, we recognize that you're not like a brick and mortar institution there. But where we start and end at our firm when we're advising on this is, you need to pretend that you're the bank. What are the due diligence requirements that a bank would go through, whether that's underwriting or your own due diligence on the property for the long term? I think most property owners that are exiting and maybe not even doing a 1031, they're just going to pay the tax and this is a retirement type deal. Think of it as a one and done situation.
Yep.
And so they don't, the things that might be deferred maintenance or things like that are of sort of no concern. We'll let the buyer deal with that.
Yep.
When you are the bank,
Yep.
you care.
You care.
Because over a 10-year period, and that's usually, 5 to 10 years, the term of the note.
Yep.
You need to be aware of what's happening with your collateral.
Yep.
Because it's not, if it gets devalued or waste occurs on the property or insurance isn't paid or there's a casualty and it's not handled properly, that is your collateral.
Yep.
That's your money that may or may not be there.
Yeah.
So what are we going to do to set this up so that we're taking care of all those issues? So
You being the seller who is now playing bank.
Yeah.
Yep.
So I essentially just make them aware that we're now in a world where we've got a whole new set of protocols. So we educate and talk about those risks, and then we create a checklist, much like a bank would do.
Okay.
Here are the things that we're going to need to work through that you should consider.
Yep.
And they've run the gamut, right? What kind of title insurance, the lender's policy you're going to have, insurance, and then maintaining that note. So there's a lot of ways we can handle the money that comes in.
Yep.
Typically, we prefer to see a third party involved, sort of taking the money, making sure that it's coming in, doing these things. So there's sort of servicing that's available that can be helpful.
Okay.
And then we prepare the client for the reality that, despite all these considerations, it might be a good idea.
Yeah.
And it's not as complex or convoluted as it sometimes gets made out to be, but we just need to be aware of the risks and take it seriously.
Okay. Outside of traditional risks of getting a loan, me as a buyer, are there any risks that are for a buyer that are greater than working with a lender versus a seller?
I would say no. One of the big things and one of the great things about seller financing is typically it's a little less onerous. The underwriting is more practical.
Yeah.
And so from a buyer's perspective, what you're trying to do is make sure that you're in fact getting terms that are better than whatever a bank would do for the most part.
Okay.
Just they're commercially reasonable in light of the circumstances.
Yep.
And you want to make sure that you're not signing on for more liability than you anticipated.
Okay.
And there's a lot of different ways that financing can go, from secured to unsecured to, obviously these will mostly be secured transactions where you have a deed of trust securing that note.
Yep.
And that deed of trust is typically in first position,
Yep.
although not always. We might do a second just to kind of get through the transaction. And then whether or not there's going to be a guarantee.
Yep. So
recourse or non-recourse.
this came up yesterday. We had a signed LOI with a buyer and seller, so letter of intent, and it had in there no personal guarantee. And then the attorneys engaged, and the seller's attorney's like, absolutely not. We need a personal guarantee. And now we're got some friction. Do you think it's pretty common to have personal guarantees on seller financing loans or not?
Yeah, I would say it's common,
'Kay.
but not mandatory.
'Kay.
And obviously it depends on whose side you're on.
Yeah.
Right?
Yeah.
And also this impacts the marketability of the property. So if you have a property that nobody really wants to touch, and the only way you can move it is by, without reducing the price beyond something you would want to do, is by doing the seller financing. And most folks are going to do that on non-recourse, meaning they're not going to be personally liable unless certain things happen. Then you can kind of go with the fact that, okay, no guarantee on this is going to be kind of what we have to do, because that's what the market will bear.
So maybe as a broker, I can educate them, hey, on a deal like this, it needs a lot of repositioning. It's going to need a bridge loan, which will require a guarantee. I think it's fair to ask for, versus this thing's pretty vanilla. They're going to do an agency loan. No personal guarantee. I think we have to move forward without that.
Yeah, and I think the way I would look at it is, if I'm selling it and it's me personally, and it's just, I would want a guarantee.
Yeah, of
right.
course.
So that's the starting point.
Exactly.
And so what are we going to do to make it so there isn't a guarantee? Well, we got to sweeten the deal or do something that would allow that.
Okay.
And so the starting position is, I would say it's standard.
Yep.
And then we work backwards.
Okay.
The asset and the loan to value are going to change that discussion. So if it's like 50% LTV.
Yeah.
All right.
Yeah.
I would probably talk to my client about are we really going to drive that bargain into the ground?
Yep.
And I think a good way to start on some of these is definitely a letter of intent, which is, I know, frustrates everybody because it's an extra
agreement to agree.
Yeah, it's an extra leg in the deal, but this is kind of where your attorney gets involved. The brokers bring it to the attorneys and say, hey, I think there's a deal here to be had, but there's these financing terms that we can't really figure out. And there's a bit more complexity to the financing terms
Yeah.
that I think if I'm advising a broker, I'm saying I think you're better off letting an attorney explain that stuff.
Yep.
I teach for SEBA on the purchase and sale agreement
Nice.
side, and one of the things we talk about is sort of where are the limits on the practice of law, and when do you want to get an attorney involved?
Totally.
Certainly financing's there, and one of the reasons that you'd bring them in at the LOI stage is so that things like the recourse can be brought in, and things like maybe we'll do one that's non-recourse, but we'll have what are called bad boy carve-outs.
Yep.
Meaning, hey, it's non-recourse unless
Yep.
borrower defrauds you or commits environmental waste or any number of, there's about 5 of these
Yep.
that you would just say, all right, in those limited circumstances, we're going to get to go after somebody individually.
Yep.
For everything else, we're limited to the value of the property.
Okay, makes sense. That takes me to my final question on seller financing that comes up often. Jared, this all sounds great. You know, I'm the lender. I'm getting checks every month. I don't worry about it. And then the buyer disappears and the property goes to waste and I have to take it back. What is the process? And from my understanding, I've been told in Washington State, it's pretty straightforward and it's not a question of whether you'll get your property back, it's when.
Yep, absolutely.
Confirming that, and then how long does it take? And can you just put a servicer in there that does it for you?
Yeah, so what you're going to do is hire a trustee. This process is called foreclosure.
Okay.
And you have judicial and non-judicial foreclosure.
Okay.
If it's over 4 units, you're talking about a commercial foreclosure. Generally speaking, it's a 120-day process.
Okay.
You hire a trustee service. There's a few of them that we like. And typically you have your attorney involved as well. There are a few attorneys that do it all together, but they're very unusual, I would say.
Okay.
And you're looking at sending some notices. And then after those notices go out, there's a notice of trustees sale that's recorded, and that's 90 days from that date. So then the sale happens, bidding happens, and you could bid your debt, and that's how you end up with the property. Obviously, if someone outbids you and you want to accept that, those will be, you'll collect the cash from the proceeds from the sale. If there's any excess, meaning it's over the amount of your debt, then it will be put into the court registry, and the borrower can make it go where it needs to go.
Interesting.
Yeah.
So it sounds like it's easier to take your whole building back from a bad borrower than one unit back from a resident.
I would absolutely say that's the case.
Okay.
Yeah.
That's good fodder for me when I'm talking to an owner about this. I'm like, hey, you've gone through an eviction. I think you can get through a foreclosure.
Yeah, and this is part of the, I definitely don't like to be somebody who's sounding self-serving repeatedly.
Yeah.
But this is where an attorney can be like, here's how this process works.
Yep.
It is enforceable.
Yep.
And you hope never to be there.
Yeah.
And in fact, I can say that we have done a number of foreclosures, but they're very rare.
Yeah.
Even in the last downturn,
Yeah.
it was more of something where there's always a deal to be made.
Okay.
And one of those deals is called a deed in lieu of foreclosure.
Okay.
I don't want to spend too much of our audience's time on this,
Yeah.
but there's typically it's less likely that the borrower is just going to disappear. It's more likely that they're having financial troubles,
Okay.
and they're going to want to make a deal.
Gotcha. So moving to another word we haven't heard a lot of in this cycle, I'll call 11 to 24, long cycle, defeasance. What is it and why is it more important right now than maybe it has been in the last decade?
So defeasance is a mechanism by which at closing certain funds are held back to pay off a loan that's going to stay in place because of the prepayment penalties or other fees that might accrue to the lender
Okay.
that would kill the deal.
Okay.
So typically and you're right, we haven't seen these in a long time.
Yeah.
And it's because
I've seen a website called Defease with Ease. That's
Yeah.
all I know about it.
Yeah, and they've got a great rhyme. It's great. I think in 18 years of practice, I've touched maybe 1 or 2 defeasances,
Okay.
and so that's just kind of where this has been.
Yeah.
And the reality is interest rates have been so low.
Yeah.
There's really no reason and banks have been so willing to work things out.
Yeah.
That this defeasance process is typically not something that happens, but sometimes it's unavoidable,
Yep.
and I suspect we're going to start to see that.
Okay.
Typically where you see it is where you have, let's say, a $10 million loan, and you've got a number of points that are going to have to be paid if it's paid off early, but you've got a buyer who's lined up to buy it. Well, what do? Well, we work together with 2 different law firms, and parties on both sides create mechanisms by which the loan will essentially be paid in full at closing,
Okay.
but it'll be paid into an account so that payments can be paid on the loan.
Interesting.
And in that way, those prepayment fees don't happen because they're being paid.
Okay.
Most of the time, loans are going to have defeasance provisions in them, and most of the time, parties are going to do their best to avoid this.
Okay.
In large part because you're paying 2 different law firms to do a lot of complex stuff and sign off on it.
So maybe size of transaction is when it comes into play.
Yeah.
Like $50 million.
Yeah, I don't
loan.
think I'd see one at 10 million, right?
Okay.
Like it's
So
just
bigger.
I'm anticipating seeing these in the tens of millions, and we haven't seen them yet. That doesn't mean much. We're not the biggest firm in town.
Yep.
But that's what that is.
Okay.
This SEBA has a great form that you can look at, and it basically outlines sort of the general mechanics. It gives the parties enough time to get counsel involved and get notice to the lender and figure out all the costs and fees, and then go and do it. It's very unusual.
So defeasance, though, in simple or layman's terms, is like a prepayment. There's a huge prepayment penalty, or maybe it's not even possible to prepay.
Yeah.
And this is like another route.
Yep, this would be another route.
Okay.
And sometimes it's allowable under the loan documents, and sometimes it's not.
Okay.
Yeah.
Okay. So something that came up this year, January 1st, 2024, the law of real estate agency changed in Washington State. And I had a few clients ask how that may affect our agreement as broker to owner. Can you just give us a quick snapshot of what happened?
Absolutely. Yeah. There's a few key points here. One, this is largely targeting the residential sector.
Okay.
There's been some Consumer Protection Act discussion, and everyone's seen the lawsuits out there dealing with NAIR, National Realtors Association.
And is this just because there was like this fixed, no matter what, it's always like 3% and like price fixing? Or?
Yeah. It has to do with antitrust violations and all of this. On the commercial side, there's a lot less impacts.
Okay.
In fact, I would say impacts are limited to adding disclosures everywhere, the type of disclosure you have to give, the agency pamphlet. Some of the titling that we used to use has been changed.
Okay. And
particularly the SEBA purchase and sale agreement now has additional provisions that disclose who's getting what when and who's broker, so that everybody knows at the outset of a transaction, and that's fully disclosed.
Okay. So just working within the SEBA form, which we do for most of our sales. There's a few more lines now filling out buyer's broker, what they're making, like just ultimate clarity. Is that what we're going
Absolutely.
for? Okay.
Yep.
Something that we're starting to run into is what's called foreclosure, or someone will say lenders taking a property back. All my clients are looking for distressed sales. This is starting to crop up a little bit. I have not seen much of it, and the data says that Washington State is not going to see much impact, at least for the next few years, when they track like where delinquency is on loan payments. So that aside, is this an issue you're starting to run into? And if so, what does that process look like?
Yes. I don't think it's sort of the free-for-all and mass distressed home sales that we saw in sort of the last downturn that was residential.
Okay.
And we did see a few commercial workouts, and there were definitely some commercial impacts in the last cycle.
Okay.
So it's not anything like that,
Yep.
but we definitely are seeing situations where there's opportunities for buyers to come in and maybe buy at less than what they would have.
Okay.
And it comes in a number of forms.
Yep.
First, obviously, is foreclosure sales.
Yep.
Those are increasing. It's not radical.
Yep.
So you're checking the foreclosure listings. There are lots of sites that'll show you when those foreclosure sales are happening. They have to record a notice of trustees sale 90 days prior to the sale. So there's a sale date out there, and that's publicly available.
Yep.
And the other form comes in just general listings of property and mostly these are going to be in the commercial side and a lot of office space, or I would say multifamily sites where properties are going to be trading at slightly reduced value based on where they were at because their financing isn't there, or the numbers don't pencil as the people thought they were.
Yeah.
And so this is a matter of just keeping your ear to the ground, being patient. And I don't think it's a thing where it's a radical price shift where there's just going to be this crazy amount of deal flow. So I'm personally, just if you're asking, I'm going to tell you, I don't see this huge market shift, which, what we saw in the residential cycle last time in 08, 09, and 10, where you could go out and be the proud owner of 10 single family properties at like 30% of what they were trading at 3 years earlier for each one.
Yep.
That's kind of not what I think we're going to see.
Okay.
And so it's a matter of when you do see a transaction that looks like it might be in the realm of sort of that exciting distress type assets, being practical, assessing the risk, and working through whether or not it's worth pursuing rather than a market transaction.
Okay. So flipping, well, I'll make one point there from personal experience. I have so many clients looking for distress that they bid against each other, and there's less distress. Switching gears though to the seller side, what I'm seeing most often is I've got a client that's done ground up development.
Sure.
Their construction loan rate is 4.5%, and they underwrote maybe a 5% loan on takeout. So they finish the building, fill it, and once it's cash flowing, they get a takeout loan at 5%, and now that's 7%. So there's no way for them to keep the property without coming up with several more $1 million into a property that might not be worth what they built it for. So let's say I'm that owner, and I'm really unhappy. I just spent 5 years of my life developing this property, and I do want to move on.
Yeah.
What do I do, like, to cause the least impact to me personally, my investors? Like, what does that look like?
Well, it's going to vary client to client.
Okay.
Because some clients, this is their only project, and I've got all of their eggs in this basket, and others, this is one of 10.
Yep.
And I would advise a client differently based on those two situations.
Let's hit both separately.
Yeah, so there's sort of a cut and run. Let's figure out how to make a deal, make a payment, end this situation where if this asset is not the only one and we're going to be fine, then it's a little easier to say, okay. We are going to lick our wounds here and move away. If it's the only thing we have and we're in trouble and this is a time for a reset and I do not practice in this area, then we're talking about bankruptcy, receivership, those types of remedies, or I would say procedures that can kind of give you that reset. And that's something that I would definitely be looking at if you're that underwater. And then finally, you are in a world where you probably need to bring on a partner because you don't have the assets required to stabilize. And I know people are reluctant to do that. I think it's Dumas said, he who has a partner also has a master. And if you've been running autonomously and with all this ability to make decisions and be agile, and now you have to bring on an equity partner. I would stop and have that same discussion that we just had about seller financing, about what that means. But oftentimes that's unavoidable. And instead of selling the property, you probably should be looking at somebody who's willing to come in and take a stake if that's available. For understandable reasons, that can be difficult. So I think this goes in the bucket of just getting creative about solutions. And this is a painful discussion because oftentimes this is somebody's baby. And we recognize that. And so we tread lightly.
If it's the one deal, it's usually the friend's money and the family's money. So there's just a lot of emotion tied up in this. So that seems to be the preferred solution. Instead of just walking away and losing everything, maybe go find a partner that comes in, maybe takes a pretty large portion of the ownership, but gives you the opportunity to refinance and live to fight another day.
And somebody listening to this might just be chuckling, like, good luck with that. Because you do have to go to the bank and say, okay, bank, I know we've stabilized this loan, but I need consent to bring on a partner because all these loan documents have due on sale clauses, which means any sale of the property or any interest that could be perceived as a sale of the property, like an entity interest, membership interest in an LLC, needs the lender's consent. So there's a number of steps here, and don't get me wrong, it's not easy or fun, but that might be something we talk about.
Okay. So there's some options though. Don't just immediately be like, I'm going bankrupt.
And bankruptcy, I'm not taking lightly. Right?
You shouldn't.
And I wouldn't want to stress the market here by saying that I think bankruptcies are all over the place and happening imminently. But if we're talking about our last asset and all our eggs are in that basket, that can be a thing.
Okay. Shifting to our last topic, which I think is another like moment in time topic, but it's like a pre-TCO or selling a building, like or contracting to sell a building before it's occupiable, certified by the city or whatever jurisdiction. So from a broker's perspective, what I'm talking about is I've got a buyer that's willing to buy a building that's under construction, negotiate the terms of that purchase to alleviate typically this situation we just talked about. And so they feel like they're getting maybe a discounted price because they're taking on the lease up risk and they're taking on the risk of getting it refinanced or I guess taking out the construction loan. You know the drill. Pre-TCO sale didn't exist first 10 years of my career. Now in the last year, we've seen a handful of these. Have you run into this? And if so, same thing.
So
clients calling you and they're like, "Hey, I'm thinking about buying this vacant, unfinished building. What are the
Yeah,
risks?"
this is why they call it the practice of law.
Yeah.
Because there's nothing hard and fast.
Yeah.
I mean, I would say that if you asked me 3 years ago, would I ever let a client do that? I'd be like, no.
Yeah.
No. And I would say it probably on both sides of the, whether I'm the seller or the buyer.
Yeah.
For a variety of reasons, we would like to see a final certificate of occupancy issued,
Yep.
and or else
Yep.
kind of thing.
Okay.
Now we're in a world where, as often happens, the market has shifted in terms of what's commercially reasonable. And I would say this about any transaction of any kind, whether you're buying or selling a business or an apartment or whatever. Your key objective is to get a commercially reasonable deal, right? And here we are in a world where, for a variety of reasons, it makes more sense to take over early and get in there and do some things and get moving, or be able to lease the building yourself and have full control of the building. Maybe there are some timing concerns. And you know what? If that's what's going to take, then you got to get creative and get into, okay, well, if we do this, so something that is not previously viewed as commercially reasonable, what are the risks? How can we mitigate those risks, contractually, otherwise? And then keep the option open of a hard no through feasibility. Like, hey, we'll try it. If we can't get what we need, look, we're just done. Like, it's not going to work because we're not getting what we need to mitigate those risks.
Okay. And as typically happens, we get to the end of a feasibility and we're not quite there. So what are, let's say, some common risks that still remain for your buyer if you're representing them, and how we may mitigate them contractually?
Yeah. So the whole point of having a CO is just knowing that, you know what, the building is done. 100% done. Not maybe, or something might come back up with the city or SDCI in King County or Seattle. And so the risk is, without stating the obvious here, just that there's something unknown that needs to be done post TCO. And so what do we do about that? Well, we talk through all the different things that we can do to reduce that risk. What does the construction contract look like? What does permitting look like? What actually is left to be done? There can be a huge variation in what people think is going to be the case post TCO to CO, and what actually ends up happening. And so, as always, if I'm involved, I try to let people know that if there's anybody else in the room, then I'm not the smartest person in the room. And that means on construction stuff, we get construction people in to do the analysis, get experts involved that aren't related to the project, to just say, hey, here's what I see. I'm looking through everything. Here's what's going to happen generally right now, because I can see by this, and this, that the TCO is going to get issued, and these are going to be the last things they're going to flag, and those things are like nothing. And then if there's anything that we suspect could be a cost item, well, you work that into it. Okay, is there a holdback for this? Just like with environmental or any other piece of a commercial transaction, you try to build in something to protect and hedge against that risk. And I think most sellers are like, yeah, sure, that's fine. Like, I do not see this as something that is going to be like an ongoing trend. I mean, maybe it comes up, but I think it's more likely that we get back to business as usual. Particularly as I see lenders saying, you know, this is not, you know, we'd prefer that the CO be issued.
And I guess I should have clarified, TCO, temporary certificate of occupancy. My understanding is the city has said this building is safe and inhabitable, and you can start signing leases as people move in. And then C of O, there were a few items. You didn't paint the planters the color we said, and you didn't secure this railing. Finish that up.
So I mean, the risk
TCO's the big one.
TCO's the big one, and the risks are fairly, I don't want to minimize it at all, but I also don't want to sound like, oh, the building might fall over. So it's definitely a risk. But here we are in this new world, and we'll deal with them and address those accordingly.
So last question on this topic, and overall, we're talking about the buyer side here in this pre-temporary certificate of occupancy purchase. What's something a seller should be thinking about? What are some risks for them? They're contracting to sell this building before it's finished. What are they committing to? How can they de-risk their side?
Yeah, I think ultimately sellers would love to have their hands on whatever contractual obligations they have being completed. So if that's payment of contractors and subcontractors and the ability to get the work completed. Because a lot of times sellers still going to remain liable post-closing to get the CO. And so how do we control that, and how do we make sure that we're going to get the access required? Because a lot of times if you're using a standard CBA form, it says possession is at closing, and now possession means possession. And the number one demonstrator of possession is the ability to just kind of lock the doors and not let somebody in.
Yeah.
So we got to be having access so that we can meet our own obligations.
Okay.
And we got to make sure that we have some modicum of control with that TCO process all the way through CO. So getting records of that and confirming that we can correspond with the government agencies to finish what we started.
Okay. I lied. Bonus question. We didn't prepare for. I think
Great.
you're going to be comfortable with. It's in the CBA PSA.
All right.
People transacting right now, there's typically a greater need for the sale than maybe like the market is just, we think it's peaking. And what I mean is there's something that's happened in the family is most common.
Yep.
So I've got families that the children are hiring me, parents had just passed away.
Yep.
And now they're being required to sign these sellers' representations and warranties.
Yeah.
And they've owned or known the building for maybe just a number of weeks.
Yeah.
So we get back and forth with buyer and seller, and sometimes counsels on both sides where the buyer's like, I need you to represent and warrant that X, Y, and Z happened with this building. And the person's saying, I don't know.
Yeah.
What do we do in that scenario?
Yeah, so typically we like to draft for that. We like to draft for specifically whose knowledge are we talking about.
Yep.
And we can put names down.
Okay.
And we can specify and I like to go right at things.
Okay.
Look, I'm the son of so-and-so. I've never set foot on the property. We might as well declare that in the contract, as crazy as that sounds.
Okay.
And then it's basically, there are some reps and warranties that I would advise my seller client who is in that position to just make, because we can give some of them. You know, there's a few that are just like, well, I just don't have any knowledge of that. I've received no actual notice of claims. So I think there is a little bit of a fear factor that sometimes is unwarranted on the side of seller.
Okay.
Where it's like, there are some that we really want to watch out for, and there are others that we need to just give because that's what they're paying for.
So you can give some.
Yep.
It's like, hey, have you, client, the seller, have you got any notices that X, Y, or Z has happened? And they say, I actually have.
Yeah.
Well, now you can.
Yeah.
Up to that.
And the ones that are, there's nothing to really run and hide from. It's like, okay, we found this out. Let's write that in.
Yeah.
Hey, except for this thing, except for this ongoing eviction that's happening, we don't have any claims, and we just go right at it, and get after it and not run and hide from the issues. And I think that tends to do a couple of things. One, it gets us to a place where we're getting some contractual language in there that makes sense for the long term. And two, it builds goodwill and good faith to get the deal closed.
Okay.
So if you're coming to the table and saying, hey, here's what's going on, rather than people finding out later, that's always a better vibe.
So what I'm hearing is, because I've dealt with this exact scenario, on one hand, I had client A, seller, and they're like, I just delete everything that comes through my email. I tear up mail. I just don't want to know. That's bad.
Wow.
Example B, they're like, hey, here's the notices I received. It looks like we're delinquent on taxes, and this is everything I have, and they're being forthright. We just go disclose that and move forward.
Yeah, so everything is going to be deal specific. So there's a lot of nuance here. Generally speaking, I would say that part of the property value that you're conveying is the documents and the history of the property and all the due diligence that's been done to maintain the property over the years. And so the more you can document that, good and bad, the more valuable your property is. Because a market buyer who's coming to pay whatever the comp price is doing so under the assumption that you've done all that.
Yep.
So everything that you don't have, that you tore up, that email, that rep that you won't give because you tore something up, that is going to be a price reduction.
Okay.
A willing buyer is going to pay less once they figure out that there's just no record of this, but something did happen. Okay, well, what else is there? And on the buyer side, when we're representing a buyer and we find out that seller either won't represent to something, or we kind of already can see that they're being a little bit sly about something, it causes our ears to perk up. And the immediate thing I tell my client is, let's keep our eyes open here, because this probably isn't the only thing where there's been some corners cut. Because that is a type of property owner. And we all are, we're all humans. We all have different strategies.
Totally.
And as we discussed about the self-help remedies from the 60s and 70s, or whenever that was a thing, there's different versions of how to run a property. And that's just part of property ownership.
Okay. Thanks for joining us today with Iman's Holmquist, Ask Your Attorney here in Seattle. Follow us, like us, comment, and reach out to me if you have any questions.